Good morning. My name is Anthony Randazzo, and I am a partner at Secrest, Wardle. Today I'll be conducting a webinar on the application of the Recreational Land Use Statute here in Michigan. The first couple of questions you may be asking yourself is, what is the Recreational Land Use Act and why do I care? Well, most people probably don't care. But if you are one of those few fortunate people who are landowners or represent a landowner who is being sued for an injury that took place on the landowner's property, you may want to take a listen to this webinar. Because the Recreational Land Use Act may provide an absolute defense to that lawsuit. So what is the Recreational Land Use Act? The Recreational Land Use Act in Michigan is defined by statute, MCL 324.73301, Pren 1 Empron. And it states, except as otherwise provided in this section, a cause of action shall not arise for injuries to a person who is on the land of another without paying to the owner, tenant, or lessee of the land a valuable consideration for the purpose of fishing, hunting, trapping, camping, hiking, sightseeing, motorcycling, snowmobiling, or any other outdoor recreational use or trail use with or without permission against the owner, tenant, or lessee of the land, unless the injuries were caused by the gross negligence or willful and wanton conduct of the owner, tenant, or lessee. Now, at first glance, the statute may seem to be quite straightforward. However, as the saying goes, looks can be deceiving. However, before we get into the minutia, let's understand why the statute was created, because it might help us understand how it should be applied. So, why was the statute enacted? Well, most private landowners, like me, are generally unwilling to open their land for public use, simply for the reason they are fearful that someone will get hurt on their property and sue them. I'm a lawyer, I know lawyers, and if someone gets hurt on my land, they will sue me, claiming that they should have been warned of some unknown condition to them that existed on my land at the time of injury. For this reason, I don't like people crossing my land. Well, my goal is to exclude the universe from my lawn and property run contrary to the prevailing public policy on the issue of land use. You see, it is public policy of the state to promote the open use of the finite resource we know as land. And not just any land or any reason, it's land to be used for recreational outdoor activities. The Recreational Land Use Statute was formulated to resolve the competing interests of property owners and public policy. Essentially, the statute was devised to promote public recreational land use of privately owned land. The statute does this by granting landowners broad immunity from liability for injuries suffered by land users pursuing recreational activities on the owner's land. That only applies, however, if the person who is injured did not pay the owner for the use of that land, or it doesn't apply in situations where the landowner was either grossly negligent or acted willfully and or wantonly. The underlying policy of the Recreational Land Use Statute is that the public's need to access land for recreation in an outspaced area is greater than the individual's need. So, to promote the land use and access to land, they provide immunity to landowners. Now, you have to realize this statute is important because it is a breakaway from the common law. Before we move into the next discussion and look at the historical and modern approach to applying the Recreational Land Use Act, it should be noted that the recreational land use breaks away from the common law and how the common law treats typical premises liability actions. Under the common law, or judge-made law, a landowner owes different duties of care to persons who enter upon his or her land. The duties depend upon the status of the individual who is on the land, such as an invitee, licensee, or trespasser. Under the common law, the greatest duty of care is always owed to an invitee. That duty is to take reasonable care to protect against unreasonable risks of harm caused by dangerous conditions on the land. On the other hand, no duty is owed to an unknown adult trespasser, except to refrain from injuring the person by willful and wanton misconduct. The Recreational Land Use Statute changes the common law in certain circumstances. In particular, under the statute, all recreational land users, including minors, are treated the same. They are treated essentially as if they are trespassers, and thus a landowner owes them no duty of care except to refrain from gross negligence and wanton misconduct. Now that we have taken a look at the reason for the enactment of the statute, let's get into a little more how we apply the statute. Much of the surrounding the proper application of the Recreational Land Use Act has focused on whether the type of land involved in a given case was the type the legislature meant to protect by the statute. In this regard, there are two views on how to apply the Recreational Land Use Act. There is the historical view, and then there is the modern view, or the current law on the topic. Let's first take a look at the historical view as outlined in a case called Wiemers versus Holmes. This is a case that actually involved two separate actions that were consolidated for appeal. The first case was called Wiemers versus Holmes, and the second case was entitled Yarling versus Bell Lake Association. Let's take a look at the facts of each case, then we're going to go and examine the holding by the Supreme Court. First, let's look at the facts of Wiemers versus Holmes. In Wiemers, Linda Weimer and her 6-year-old daughter were visiting the home of Linda's sister and brother-in-law during the Memorial Day weekend in 1981. Linda's sister and brother are the defendants in that action. In the back of the defendant's home was a man-made pond. While the parents, including Linda, were inside the house, children were outside playing near this man-made pond. Now, they were playing near the pond in a shallow area, catching pollywogs in a bucket. After some time, the children returned back up near the house to play around that area, all except for Linda's daughter, Jennifer. Jennifer continued to play near the pond, and with the parents inside, Jennifer drowned in the pond. Subsequently, Jennifer's father brought suit against the defendants, claiming in his case that the defendants failed to warn Jennifer that there was a drop-off in the pond where his daughter drowned. Now let's take a look at the facts of the consolidated case, Yarling versus Bell Lake Association. In that case, plaintiff Yarling was invited to a birthday party at the home of Mr. and Mrs. Grannis Yarling. I apologize if I misspoke. Actually, Mr. Yarling was invited to the house of Mr. and Mrs. Grannis. Yarling was the person who was invited and the plaintiff in this action. Once at the party, Mr. Yarling was subsequently invited to another party in the same subdivision at the Brontowski home. The Brontowski property was continuous with a private park in the Bell Lake Estates subdivision. That park abutted a lake, which was also part of the park area. When Mr. Yarling arrived at the Brentowski home, one of the swimmers, who was familiar with the lake, ran down a hill at the edge of the lake, made a shallow dive, and entered the lake. That swimmer then called the attention of Mr. Yarling and asked him to join him in the lake. As such, Mr. Yarling ran down the hill to the water's edge, where he saw some telephone poles which had been apparently put there to prevent soil erosion. Mr. Yarling found himself unable to stop due to his momentum, which caused his legs to flip over his head, causing him to land on the back of his neck in 14 inches of water. Mr. Yarling sustained significant injuries, including a cervical fracture, leaving him paralyzed from the shoulders down. The lake was owned by the entire subdivision, and subsequent to the injury, plaintiff brought an action against more than 200 defendants, including the Neighborhood Homeowners Association and individual lot owners. Okay, so these are the facts of both these cases. So the next question is what did the Michigan Supreme Court have to say about these facts and whether or not the recreational land use statute applied to bar either of these actions? In both cases, the Michigan Supreme Court was asked that question. Let's determine the applicability of the recreational land use statute. In doing so, the court looked at the plain meaning of the statute as well as the facts of the respective cases. And in both cases, the Michigan Supreme Court held that the Recreational Land Use Act did not apply to either action because the language of the Recreational Land Use Act, read in light of the legislative history, is intended to apply to, quote, large tracts of undeveloped land suitable for outdoor recreational uses. The Wiemers Court placed a significant limitation on the application of the recreational land use statute. In particular, it relegated the use of that statute to only large tracts of undeveloped land. Thus, it did not apply in situations such as the case in Yarling and Wiemers where the land was in subdivided areas on smaller tracts of land. The Wiemers decision came down in 1986. This was the law for nearly a decade. That was, of course, until the Supreme Court revisited this issue in 2004 in a case called Neal versus Wilkes. Again, let's look at the facts of Neal because it'll help us compare the case of Neal to the earlier decision in Weimer. In Neal, the plaintiff sustained injuries while driving an all-terrain vehicle, an ATV vehicle, on defendant's property. The vehicle was driven by defendant's brother on defendant's property. When defendant's brother drove over a piece of uneven land on defendant's lawn, plaintiff was bounced from the ATV, causing severe injuries to her back. Defendant's property was on approximately 11-acre lot that was zoned residential. Although portions of the lot were wooded, plaintiff sustained injuries while riding the ATV vehicle on the mowed portion of defendant's backyard. At the trial court level, the trial court granted defendant's motion for summary disposition on the basis that the Recreational Land Use Act barred plaintiff's cause of action. However, based on the decision in Wiemers, as we just looked at, the Court of Appeals reversed the decision of the trial court, holding that the Recreational Land Use Act only applied to large tracts of undeveloped land. Subsequently, defendant filed an application to the Supreme Court, which was granted. The issue before the Supreme Court concerned the proper interpretation of the Recreational Land Use Statute. In particular, the question considered was whether the Weimer Court got it right in limiting the applicability of the Recreational Land Use Statute to only tracts of large undeveloped land. In reading the plain meaning of the statute, the Neal Court held, essentially, that the Wiemers Court got it wrong. In fact, the statute itself, they suggested, placed no restriction on the size of the land. It placed no distinction on whether the land had to be large versus small, developed versus undeveloped, vacant versus occupied, land suitable for outdoor recreational activities, and land not suitable for recreational activities, urban and suburban, rural land, subdivided or unsubdivided land. There's nowhere in the statute that specifically limits the type of land to large tracts of land. It's not a condition precedent to applying the statute. So the Neal Court held that to place such limitations, to read such limitations into the statute would run contradictory to statutory construction and statutory interpretation. In short, the statute contained no limitation on the type of land involved, but rather applied to specific activities that occurs on the land of another. Therefore, an owner is not liable to a non-paying outdoor recreational land user unless the user's injuries are caused by the owner's gross negligence or willful and wanton conduct. There is no threshold requirement that a defendant asserting the defense of the Recreational Land Use Act must first show that the land is somehow big enough or large enough or undeveloped enough before the application of the statute. That's a huge change in the case law, and it really opens up the availability of this defense to landowners. And that would be all types of landowners, because as you see in Neal, that was his backyard, the mowed portion of his backyard. So, again, just to summarize, the court addressed two issues in its decision. Essentially, the court held that land simply means land. There is no limitation on the type of land involved. And the second thing, and a very important thing that the court looked at, was the activities that were covered by the statute. If you look at the statute, the legislature spells out different types of activities, different types of recreational uses in which the statute would apply. In particular, the statute specifically sets forth fishing, hunting, trapping, camping, hiking, sightseeing, motorcycling, snowboarding, snowmobiling. Presumably snowboarding would fit this, or any other type of recreational land use. See, there's a kind of a catch-all there on any other outdoor recreational land use. And in the Neal decision, they talk a little bit about this in explaining the catch-all or expanded view of what is considered recreational activities. The Neal Court really relied on the doctrine of iustum generis, which is Latin for of the same kind. In particular, when a general term follows a series of specific terms, the general term is interpreted to include only things of the same kind, class, character, or nature of those specifically enumerated. As we saw in Neal, the court found that riding an ATV vehicle was of the same class, kind, character, nature as the enumerated activities identified in the statute. So the statute applied. However, it should be noted that no court at all has gone so far as to specifically limit the activities that would fit the statute. This is important because it's now at least arguable that if something may be an outside activity, that it would fit the statute. And the reason I say this is when you look at the statute, you look at the types of activities involved, it's pretty broad. I mean, if sightseeing can qualify as a recreational activity, it seems to me, at least, that there's not much that could not be considered a recreational land use activity to fit this statute. Okay, now that we've looked at the situations in which the Land Use Act would apply, the recreational land use would apply, I would be remiss if I did not at least talk a little bit about situations in which a landowner would be liable, notwithstanding the enactment of the Recreational Land Use Act. The first situation that you would remain liable for injuries on your property, or I guess a better way to say it would be a situation where this statute would not apply, would be where an injured person actually paid you valuable consideration for the use of your land. The statute specifically states that in situations where valuable consideration was transferred to the owner for the use of that land, the statute does not act as a bar to this type of action. Now, just to, I guess as an aside, Michigan cases have uniformly held that valuable consideration, to meet the definition here, to, I guess, void the statutory bar, it has to be a specific fee for use of a particular recreational area in question. So, if you're paid, you kind of lose the right to this defense. That's one issue that landowners should be cognizant of going forward. The second situation, or I guess the second set of facts that would prevent the use of this defense, would be a situation where the landowner was grossly negligent or acted willfully or wantonly in causing the plaintiff's injuries. Now, again, you might be saying, well, what does that mean? And on that, gross negligence has been defined time and time again as that conduct that is so reckless to demonstrate substantial lack of concern for whether an injury resulted to the plaintiff. That's cited in Sue versus Gay, 257 Mishap. And in those situations, you know, you're not going to be able to take advantage of the Recreational Land Use Act as a defense. Willful and wanton misconduct, similarly, is defined as conduct that shows an intent to harm, or, if not that, such an indifference that, and whether harm will result, which would be the equivalent to his willingness or her willingness to do so. These situations are, I guess, somewhat easy to imagine, and this is, it reminds me of my father, who just absolutely hated neighborhood kids crossing his corner of his backyard, because we lived at a field that kind of led into a park area, and we used to have these kids cross this corner, and it made a footpath. And my father took his lawn pretty seriously, so I could see my father, if he dug a hole, put some leaves over it, and a kid fell in the hole, I don't think my father would be allowed to get out of that case based on the statute, assuming, of course, a recreational land use activity was taking place. So that's, I guess, one clear example of when the statute is not going to apply. And I guess there are various others like that, but, you know, it shows you that it's kind of a high threshold. Now, as an aside, some of you may be interested in whether the statute provides an exception to governmental immunity. Some of you may be governmental entities looking to this as a possible problem, because the fact the statute doesn't apply where consideration is paid. A lot of cities will accept payment for use of the land and recreational activities, and as we saw in our prior discussion, payment of valuable consideration kind of, I guess, strikes a hole through the ability to use the Recreational Land Use Act as a defense. But be that as it may, rest assured, governmental entities, that the statute is not an exception to governmental immunity. Remember, the Recreational Land Use Act only provides protection to general landowners, and since there is a more specific statute that protects governmental entities, the Governmental Immunity Statute, and it's more specific and enacted after the Recreational Land Use Act. If the legislature wanted to carve out an exception to governmental immunity to allow for causes of action, then it would have done so in the Governmental Immunity Statute. But this issue was addressed in 1998, and it was addressed by the Supreme Court in a case called Ballard, B-A-L-L-A-R-D, versus Ypsilanti Township. The citation is 457 Mich. 564. If anyone's interested in learning additional information about that, they can email me, and my information will be presented shortly. So again, the Recreational Land Use Act does not provide some type of an exception to pursue cases against a governmental entity. And on the screen right now, there are some additional examples of other situations that impacts landowner liability and the application of the Recreational Land Use Statute. For example, if someone crosses your land while cross-country skiing and falls, injuring himself, you may not be liable, assuming, of course, that you were not paid for the use of your land and you did not act grossly negligent. Same applies to snowmobiling across your parking lot. You as a landowner are not liable unless, of course, you receive pay for the use of your land and or you acted grossly negligent. And obviously, you can see why now the not the Supreme Court, but the legislature chose not to create somewhat of a laundry list and just use examples of recreational land activities, because they are many. And if you're outside and you're playing around or having fun, you're usually in a recreational activity sport. And if you get injured on someone's land and you didn't pay them, you're going to have a tough time suing them because of this act. Well, I really appreciate and enjoyed giving this webinar, and I'm really happy that you all paid attention this long. I know it's a little bit of a dry area, but I think, although these cases don't come around every day, there may be a situation where the statute would apply to I guess, help you in the defense of whatever action that you find yourself in. If you would like any additional materials on this subject, I know some of the materials that were listed in the webinar, the slides, weren't. I didn't have. I have more things in my office here that I could give you guys, or just talk about the webinar and or any other situations you may find yourself in where the statute may apply. Again, if you are a landowner or you're representing someone who is a landowner, insuring someone who is a landowner, and you find yourself as a defendant in a personal injury manner, you may have an absolute defense to the action. You got to look at who owns the land. Did anyone pay for the use of the land? Was the person, the plaintiff, involved in an activity that could constitute a recreational activity? And just want to make sure that you or your insured was not grossly negligent in causing the injury to plaintiff. If you have good facts, then you got a great defense here. Again, this concludes my webinar. I appreciate your attendance, and if you have any questions, comments, concerns, or would like to discuss this matter further, my contact information is right here. Unfortunately, this is being taped because I'm in trial, but I'd be more than happy to speak with you at some time in the future. Again, thanks for your attendance.